Lord, once upon a time, the late fellows Lord found me in a court. I was all alone by myself. That was 12 years ago. Fairly young with black hair. There is me, who are 25 advocates. The Rose told me, Nelson, there are many, they will overwhelm you, but you are on the right. My starting point is this. In this matter, I'm advantaged and also disadvantaged. Advantaged for the reason that I've been brought to court and that I can speak my mind because I have a case to answer. I'm disadvantaged because, notwithstanding what Article 27 of the Constitution says, that every person is equal before the law and has the right to equal protection and equal benefit of the law, I'm not oblivious of the fact that the name Nelson Havi is not preceded by the two prefixes, Honorable Mr. Justice or Honorable Lady Justice. That's a fact. And it is for that reason that the adage used by my colleague and very good friend, Julius Kempori, is apt. Fear or favor. I fear because I'm not equal to these judges who have brought me to this court. I'm not. And I have no illusion about it. And that is why I took the 7 judges to the Judicial Service Commission. They have brought me before their peers. Don't worry. I know what I'm doing. My lords, when you sit down, I want you to have no illusion. And this is my fear. I know this application will be dismissed. I said I have an advantage. I know it will be dismissed. I also know the petition will be allowed. But I have no problem with that. What I must do is do what one must do when confronted with fear. When confronted with fear, you either fight or take flight. I've decided not to take flight, but to fight, knowing very well what my eventuality might be. So, without introduction, let me traverse what my colleagues have put as points of law. Starting with my learned senior and good friend, Mr. Uraro, it is true that the decision for empanelment by Justice Bahati Mumwe was made on 11th of April. And the one by Justice Lawrence Mugambi was made on the 25th of April. He is of the view that I ought to have appealed or reviewed. I'm always very mindful of what President Ronald Reagan said. Those in charge of the system will tell you follow the laid down procedures. In my short life here on earth, I don't follow laid down procedures because I know who are in charge of the systems. But fundamentally, Rigathi Gachagua was decided on the 9th of May 2025. It is the operative law. And it has said where the Chief Justice is a party to a litigation or is substantially affected in litigation, it will be prudent that he or she does not a panel, a bench. And this is not said from the emptiness of my head. It is stated from the wisdom of the case of Yaqub and another versus the Queen, which you will find at paragraph 22 of my submissions. It's quite clear. And in that case, the Privy Council said it was wrong for Yaqub to empanel a bench to hear an appeal from his decision. So if it was wrong for Yaqub to empanel a bench to hear an appeal from his decision, it is grievously wrong for Martha Koome to empanel a bench to hear her own case. I fear. My learned friend, Mr. George Oraro, stated that it will be inconsistent for part of this petition to be delegated to the Deputy Chief Justice and part of it to remain with the Chief Justice for purposes of empanelment because they are conjoined. Yes, they are indeed conjoined. But whose problem is that? It was not the expectation of the drafters of the Constitution that the Chief Justice and judges will be embroiled in litigation with mere mortals like Nelson Havi, who do not have prefixes before their names. My colleague, Madam Bett, stated that this application is res judicata and offends the principle of finality. She proceeded to read the decisions by Honorable Justice Bahati Mabwe and Honorable Justice Lawrence Mugambe to indicate what they had determined. That's why I fear. And you say, my Lord, as you consider my fear, vis-a-vis the favor I posit will inure to the benefit of the CJ and the other judges, take this into account. None of these 7 judges have filed a replying affidavit to controvert my fears. None. I may be wrong in my fears. I'm entitled to be wrong. But nobody has assuaged my fear.
Lord, I would hate to interrupt, but I think he's made a statement that is not correct. There is a replying affidavit to his application.
Oh, Isaac Leonard.
Yes.
He said he's suing me anyway. Fine. That's why I feel.
My Lord, that's my client. I didn't want to interject because
he's also my friend. We eat and drink.
It doesn't make no difference in the proceedings come before you. I thought you would be speaking on the law. And my Lord, I think you did not give directions on how long. It's about lunchtime, sugar and all that.
I'll be done in 5 minutes.
Be more than the audience.
My Lord, you know, and I need the youthful advocates to learn. You needed to have listened to Richard Otieno Kwach and Dr. Hamino present the case of SM Otieno. This is what we are trying to do, to speak. So let me just conclude with the precision. Keboi also said that if my fear was to be countenanced as legitimate, then the president who appoints judges before this Commonwealth in Kenya should have the greatest fear. I've sat with the president time without me. I can tell you without any fear of contrition, he fears. But the fact of the matter is this: the president does not appoint judges. he just swears them in. Judges are recommended for appointment and appointed by the Judicial Service Commission. Another person who receives a lot of favor is the Attorney General. He will come to court, no replying affidavit, no grounds of opposition, no submissions, but he'll still be heard. That's the reason why I fear most. My very good friend Joshua Malizo, I'm very happy to see you and meet you in person finally. He has said, my application for all practical purposes is a judicial review application. He has also said, if my fears were legitimate, the Judicial Service Commission should fear most, because as the one that recommends for appointment, it still loses all cases in court. No, that premise is not correct. The Judicial Service Commission loses most cases in court because the cases are filed by judges or magistrates. It's not by the Judicial Service Commission. Again, this is not a judicial review application, and it ought not to be one. This is an application to recuse the bench empaneled by the Chief Justice, who is the first petitioner, so that the Chief Justice can do the correct thing again. Humbly request. I'm not saying you allow my application because I know you dismiss it. Humbly request that you do the right thing. I'm also